Good evening, everyone. I am CA Gati Gupta from Meerut, the moderator of this webinar. We're delighted to welcome you all in this webinar being organized by CCLEA and NPO Committee of ICAI. It is my pleasure to be the moderator in Know Your Law series, part 32. The theme for today's webinar is Digital Personal Data Protection Act 2023, Overview and Implication for CAs, being conducted on 26 October 2023 from 4 p.m. to 6 p.m. The speaker for the session is CA Kamal Virji. This session is being organized by the Committee on Commercial Laws, Economic Advisory, and NPO Cooperative of ICAI. Let me take a moment to apprise you about this organizing committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO corporates. Our eminent and learned speaker will talk on Digital Personal Data Protection Act 2023 in this webinar, and we are hopeful that the same shall be useful to the members. Let me quickly brief our audience about the respected speaker, Sir C. Kamal Virji, who is a fellow member of ICAI. He's a first-class commerce graduate from Deen Dayal Upadhyay College, University of Delhi. He has qualified post-qualification courses like visa, and also he is an insolvency professional registered with IBBI. He has pursued certificate course on BRSR conducted by ICAI. Not only this, he is a qualified social auditor by clearing the exam held by NIS. He has been the member of Board of Studies, Study Material Research Group of NIRC, and a special invited member of Accounting Standards Board. He has also served as a member in Financial Reporting Review Board of FRRB ICAI and Ind AS IFRS Implementation Committee of ICAI different point of view. He's also the resource person for Peer Review Board, Corporate Laws and Corporate Governance Committee, and Committee on Financial Market and Investors Protection of ICAI. He has also addressed on IFRS for the members of National Board of Accountants and Auditors, Tanzania, East Africa. Besides being a regular guest speaker for IFRS and management development programs at various forums, including ICAI and ICSI, he is also an author of over dozens of books and has written commentaries on various issues like IFRS, Ind AS, CARO, statutory audit, insolvency and bankruptcy code, PMLA, internal audit, etc. He has to his credit the contribution of Just of Accounting Standards and Auditing and Assurance Standards for Volume 2 of Company Law published by BLH and various articles for NIRC and CIRC of ICAI newsletter on FBT, MET, VSOX, CARO, BIMA, etc. And a series of articles on daily value-added tax, taxation, accounting, and auditing aspects for journal text and corporate references, including various articles on external commercial borrowings, direct taxes, and foreign investments for TC. He possesses a rich industry experience in the areas of corporate laws like Companies Act, trademark taxation, foreign collaboration, joint ventures, etc., audits and management consultants. So, Kamal sir, we are delighted to have you amongst us. Our audience is eagerly waiting to listen from you, and we expect that they will have a lot of key takeaways from your session. So, you are wholeheartedly welcome, sir.
Thank you, Gati ma'am, for this introduction. And I'm thankful to the committee for inviting me to this program. So when I was invited for this program, most of the friends and the colleagues were asking me a question, whether DPDP Act is having anything to do with the chartered accountants. Answer is yes. And when I say yes, I will be dividing my yes into two segments. One is your obligation, and more importantly, second is the opportunity. So DPDP Act can be one new domain in which the chartered accountants can practice into, can be advisors also. I will be sharing my PPT in a while, but before I share my PPT, I have few questions and I would be glad to have the answers if Gati ma'am can pass upon. And I have a small request. Please don't search on Google for the answers. Try to reply the answers out of your own logic. So question number one for the audience is whether DPDP Act, I mean the Digital Personal Data Protection Act, which we will be discussing in a while, whether DPDP Act applies to the working papers maintained by the auditors. So keep this question in mind. We will discuss with some case studies also. Question number second is, you must have seen when you're visiting some commercial complex offices, when you make an entry into the office, at times you are required to give your details at the attendance register for the visitors register. Now, this visitor register can be of two types, manual register or maybe e-gate register. So sometimes you have to give information about your phone number, about your ID proof. Whether this DPDP Act applies to that kind of entry which you are making on the visitors register. Let me ask you one more interesting question for that matter. Question number third, when you registered for this program, which this committee is conducting, you might have filled up a form. And in that very form, your membership number, your email ID, maybe 2 or 3 more information must have been filled in. Whether DPDP Act applies to this committee also, who is seeking information from various members to participate. Now, let me ask you one more interesting question, question number 4. Just a few moments back, Gyati ma'am gave my introduction. Now, whether it was legally valid or not, that we will discuss at a later stage. But the question is, when Gyati ma'am was giving my introduction, whether this introductory part was in the scope of DPDP Act or not. And now why this question becomes important, most of the people are under a misconception that DPDP Act applies only to entities. Let me make a thing very clear. DPDP Act applies even to individuals. So it can apply on me also. It can apply on Gyati ma'am also. It can apply on the technical support staff of ICI also. So we'll discuss all these things, and I would be having a suggestion that audience should keep their pen and paper ready to take some critical elements which I'll be saying. Obviously, as far as PPT is concerned, I believe ICI might be circulating or maybe hosting on the website. So Gyati ma'am, I am sharing my PPT. Just confirm me once my PPT is visible.
Sure, sir.
I believe the screen is visible with PPT.
Yes, sir. And sir, by asking these questions, you have really, expanded our curiosity.
Yeah, and if I add some more curiosity to this whole episode, when you started your introduction, so you said I am CA Gyati from Meerut. Now, this word Meerut is heard by so many people now. So question arises, I heard that you're from Meerut. Other participants also heard that you're from Meerut. Whether DPDP Act applies on us regarding your this information. So we have to discuss all these things. And that's why I told you very minutely in the beginning that we cannot take this law as a mere law or a piece of literature. It has implications. And chartered accountants as well, I must say, having a very good opportunity to have a new practice potential in this law. So here we start. This law is named as Digital Personal Data Protection Act 2023. And the topic given to me is DPDP Act 2023, Overview and Implications for Chartered Accountants. We will discuss some case studies and examples as well to understand the integrities and nitty-gritties of this law. And before we discuss the law, I have 2 things to share. The discussion which I am making is based upon these various sources. And I have a small disclaimer also. I would be using some examples over here and some names also. Those examples and names are purely academical and they have nothing to do with the real or apparent connection or context. So let us start this DPDP Act with some set of questions. We will answer these questions gradually, but to begin with, let us have a kind of index. So basic questions are whether DPDP Act applies to the following cases: PAN, other KYC details, login information, etc. of clients obtained by chartered accountants during the course of their engagement. Number second question is whether DPDP Act applies to third-party information of the client, such as external confirmation requests made by the chartered accountants. Number third, internal control systems. Number 4, information in minute books. Number 5, working papers and audit reports. So now audit report is again a document over here. It contains some information, whether DPDP Act applies to the audit report signed by you. Next is email ID, phone numbers saved in the database of any entity, such as inquiry emails, inquiry calls, etc. Then employment contracts, then biometric attendance. Now, this last one, biometric attendance, is quite common. It is prominent also in most of the entities. So all these scenarios we will discuss gradually, but ultimately the thing is same. DPDP Act comes not only with challenges, but also with the opportunities. So what the background is of this law? India was not having any specific law for data protection, although we were having Information Technology Act, which was regulated in some extent only. Now what happened? A new law called as Digital Personal Data Protection Act, in short, which I am calling as DPDP Act, was assented by the President of India on 11th of August 2023. It's a 21-pager act only. When you will download the Bare Act, only 21 pages are there. And these 21 pages comprise of total 44 sections, which are spread over 9 chapters. So in DPDP Act, we have 9 chapters, which comprise of 44 sections. As of now, the situation is like that. The act has been assented by the President of India, but the law itself says various dates can be notified with respect to various provisions of the act. So the act is yet to come into force, although it is notified. And second thing is, various rules under DPDP Act are yet to be notified. Very soon it will be notified. If you will search on Google, there had been news that DPDP rules will be notified sooner, maybe in December. So ultimately, as of now, the situation is DPDP Act is a law which is yet to be enforced, because the law says that various dates will be notified for various sections. Now, how they will be notifying, that time only will tell. One important thing which we need to remember, DPDP Act cannot be read in isolation. We also need to understand and go through SPDI rules. See the last point, SPDI rules. In my experience, I found that most of the corporates in India are not complying with SPDI rules. What are these SPDI rules? I will discuss at a later stage, but for the time being, we can only understand that these SPDI rules are dealing with sensitive personal data or information, and that is why the name is Information Technology, Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. These rules were notified by virtue of Section 43A of Information Technology Act. We will discuss very briefly what these rules are and why discussion is important. You will get to know when I will touch upon these rules. So, important point which we must keep in mind pervasively is that even after DPDP Act, due consideration needs to be given to the Information Technology SPDI rules. Now, what is the applicability of this act? Be very careful with these emboldened words. Processing of digital personal data. I read, the DPDP Act applies to processing of digital personal data within the territory of India, where personal data is collected in digital form or in non-digital form and digitized subsequently. Now, just see very carefully, there are 3 different words. One is processing, second is personal, and third is data. We will discuss all these 3 words in a while, but we need to understand, this act will be applicable only when there is a data. Number second, that data is a personal data. And number third, that data is processed either in digital form or in a form which is digitized subsequently. For example, I gave you my voter ID. You photocopied it and stored it. So now what happened, my voter ID is being digitized subsequently. When you scan a document, it is a subsequent digitization. So a subsequent digitization of a non-digitized data is also within the scope of DPDP Act. So I read once again, the DPDP Act applies to processing of digital personal data. Now, what is the meaning of processing? We will see. What is the meaning of personal data? We will see. And what is the meaning of data? We will again see. These 3 definitions are important. But we need to understand over here, the understanding goes like this, that even the data which is not in electronic form, but is converted into electronic form subsequently, this act will be applicable. The best example could be scanned documents. Very prominently nowadays, there is a practice. There is a audit file maybe, and some papers are there. What people are doing, they are taking a camera shot of those papers and are exchanging the same on WhatsApp. You must have seen PDF documents, camera shot documents are exchanged on WhatsApp. So when you are exchanging the documents on WhatsApp, what will happen? DPDP Act will be applicable. In chartered accountant firms, this is quite a prominent practice amongst the article assistants, amongst the chartered accountants also. So if you are exchanging clients' non-electronic data via WhatsApp or via email by scanning, then this DPDP Act will be applicable. But yes, this DPDP Act will be applicable only when this data is a personal data. So one question which remains pending is, what is the meaning of personal data? The law further says The act also applies to processing of digital personal data. See the words, again the words personal data are coming. The act also applies to processing of digital personal data outside the territory of India if such processing is in connection with any activity relating to offering of goods or services to data principals within the territory of India. So, for example, you have subscribed some magazines or journals which are published in USA. And to subscribe those magazines or journals, you are providing some information to those publishers. In such a case, this act will be applicable even beyond territory of India. Other example could be you subscribed to OneDrive or a Google Drive and you paid some subscription money. But before payment of such money, you also shared your other vital information. And this information is processed, say, in USA. Even then, this act will be applicable. So this act will be applicable to MS. This MS means Microsoft. This act will be also applicable to Google, so long as they are processing digital personal data. Now, what is processing? What is digital personal data? We will see in a while. So one thing is surely certain here. We should be under no misconception that this act applies only in Indian territory. This act can extend beyond Indian territory also, but there is a condition. The condition is the digital personal data outside territory of India is processed in connection with any activity related to offering of goods or services to data principals within the territory of India. Now, there's a new term coming up, data principal. What is data principal? Data principal means owner of the data. So if I am saying my voter ID, then I am the data principal of my voter ID. Jyati ma'am said that I am a resident of Meerut. That means this information that she is a resident of Meerut is her personal data and she is known as data principal for this personal data. Now, we need to remember one thing always. This thing is not explicitly written in the law, but yes, it is required to be understood. Data, that is the context of this law, can be divided into two parts. Although this is not written in DPDP Act, but out of my experience, I'm telling you this thing. We need to understand through this area only. Data can be bifurcated into two parts. One is non-personal data, that is the data belonging to other than individuals, and then the personal data, that is the data belonging to individuals. Now, when we come to personal data, that is the data belonging to individuals. I emphasize the word individuals. There can be further two subcategories: regular personal data and sensitive personal data. Regular personal data and sensitive personal data. Please keep in mind, DPDP Act applies only to personal data. DPDP Act applies only to personal data. You must have got a hint that personal data belongs to individual and only that data will be covered by DPDP Act. Although there is a big definition of personal data, we will go there, but the basic benchmark is that this data will become personal data when it belongs to individuals. Now, if this data is a regular personal data, then what we will do, and when it is a sensitive personal data, what we will do, we will see in a while. The law further says that Act shall not apply. Act shall not apply to following. Number one, personal data processed by an individual for personal or domestic purposes. So if the data usage is for personal or domestic purposes, this act will not be applicable. Number second, like I can give you example also. Personal data processed by an individual for personal or domestic purposes. Let us take an example. Gyati ma'am purchased a new cell phone and what happened? She introduced a password or a pattern lock to open that cell phone. Then what is she doing? She is processing the personal data for her personal purposes. This act will not be applicable. She introduced a password to log on to her computer system. That password being stored by the computer is only for her personal or domestic purposes. This act will not be applicable. Number second, personal data that is made or caused to be made publicly available. The words publicly available are very important. Personal data that is made or caused to be made publicly available by the data principal, in layman's sense, that is the data owner, to whom such personal data relates, or by any other person who is obligated under law to do so. So if the data is made available, which data? Personal data. If the data is made available, that is the personal data made available publicly, either by your own purposes or by any legal purposes. then this act will not be applicable. So let us take an example before we read all these three examples on screen. You must have seen CCTV installed on roads. You must have seen CCTV installed in offices. You must have seen CCTV installed in housing societies. So whatever CCTVs are capturing is a personal data of various individuals, and to such data being captured by CCTV, DPDP Act will not be applying. Why? Because it is the information which is made publicly available. This publicly available will also be supplemented by Section 7 of the Act, which I will cover in a while. But please remember, the data which is made publicly available will be outside the clutches of DPDP Act. Let us understand with some three examples, which are normal examples. So example number one, Ms. Tarla Dalal, say, it is a hypothetical situation over here. Ms. Tarla Dalal is an active influencer in social media and maintains a public account and a private account. She writes a blog on food recipes and provides personal data about herself with reference to use and results. Now here DPDP Act will not apply. Why? Because the information is made publicly available. Number second, Mr. Sanjeev Kapoor is an active food blogger and reviews all food joints and restaurants and posts videos and photographs of his culinary journey and provides information about location, time, preferences to his followers. Again, this information is made publicly available, so DPDP Act will not apply. Number third, Mr. Z has an Instagram and Facebook account and makes a personal post which can be accessed, I emphasize, can be accessed and seen only by a restricted or a closed group, and it is not open to public. So it's a private account which is not open for public. Only friends can access. In such a case, this information is not publicly available and DPDP Act will be applicable. So you must have got some sense of how the application of this law will go and how the exceptions will go hand in hand. Now, what is processing? The law defines in Section 2, processing. Just see very carefully. Processing in relation to personal data. Let us stop here. Processing in relation to personal data. That means personal data is a quintessential element to fall into DPDP Act. Before we read the definition in full-fledged manner, let us first understand what is data and then understand what is personal data. So I am skipping first point for a while. Let us come to data definition. Data means a representation of information, facts, concepts. Be careful and be very attentive over here. Opinions. The word is opinion. So audit report contains opinion. An audit report can be falling in the definition of data. Whether it will fall into definition of personal data or not, we will see at a later stage. Now, I am reading this data definition again. Data means a representation of information, facts, concepts, opinions, or instructions in a manner suitable for communication. Suitable for communication. Audit report communicates to members of the company. Interpretation or processing by human beings or by automated means. Processing by human beings or by automated means. Personal data. What is personal data? Although I already covered, but yes, let us have a full-fledged definition. Personal data means any data. Data means, we have seen the second point of definition. Personal data means any data as defined above. And what is this data? Data about an individual which is identifiable by or in relation to such data. So what you need to understand, for the scope of DPDP Act, only personal data is covered, and that personal data means the data which belongs to individual. So data belonging to other than individuals will not form the part and parcel of DPDP Act. Now, what is the problem with this law? They have used the word identifiable by or in relation to such data. Now, what can be identifiers? It is not been defined by the law. Maybe in times to come, this will be defined. And if it is not defined, it will be open for subjective interpretation by different professionals. But yes, one thing is certain, that this law applies to personal data belonging to individuals only. And that is why if I go to the chart I shown you earlier, just see this chart once again. Data can be of two types, non-personal data and personal data. Non-personal data means data other than for individuals, and personal data means data belonging to individuals. And it is this second segment, that is personal data, to which DPDP Act will be applicable. Now let us understand what is processing. So they say processing in relation to personal data means a wholly or partly automated operation or set of operations performed on digital personal data. Now, what is digital personal data? You know very well. It could be the data in electronic form at the inception, or it could be the data converted into electronic form at a later stage. I gave examples of WhatsApp exchange, email exchange, and so on. And this processing also includes operations such as collection, recording, organization, structuring, storage. Please keep this mind open for the word storage because one case study will come up. Adaptation, retrieval, use, alignment or combination, indexing, sharing, disclosure by transmission, dissemination, or otherwise making available, restriction, erasure, or destruction. So let us take an example, although I will resolve this example at a later stage. Today, when this program was organized, I was asked to share my photograph and my brief profile. Now, what happened? I shared this information. Let me assume I shared this information to one of the technical support staff of this committee. And then this technical support staff shared this information to Gyati madam. Now, question arises, when this trail of sharing took place, I need to ask this question number one, and I would be glad if Gyati ma'am or any other participant can answer. Question number one, when I shared this information to technical support staff, whether this information was a personal data, answer is yes or no?
Yes, sir. It was
Answer
personal.
is yes, it's a personal data because it belongs to Kamal as individual. Number second, when I shared this information to technical support staff, whether it was digital personal data, answer is yes, because it was shared in electronic form.
Right, sir.
Now, again, what happened? The third trail is this information which I shared to technical support staff, whether this information was publicly available. Answer is no. This information was not publicly available. Now,
Right.
what happened? The technical support staff shared this information to Gyati madam. Now, question arises, whether this onward sharing is processing?
Yes, sir.
Answer is yes, it is processing. Now, having understood personal data, digital personal data, and processing, now please tell me whatever information technical support staff shared with Gyati madam was in contravention of DPDP Act or not. Now keep this question in mind, and Gyati ma'am, I will come to you again for this question, and then I will ask you whether there is a contravention or not. And I request Gyati madam and other participants, do not search on Google about this answer.
Okay.
Now, this is question number one, and I would be glad if the participants can respond this question. And Gyati ma'am, please help me with the answers the participants are giving. So question number one is, Mr. A is the statutory auditor of XYZ Limited. Let me recall you, we are discussing the topic DPDP Act implications for chartered accountants. So now this question belongs to chartered accountants. Mr. A is the statutory auditor of XYZ Limited. Question point number second. He has used the expert opinion given by Mr. B, an actuary, for expected employees obligation of XYZ Limited in terms of Ind AS 19. You know very well, Ind AS 19 deals with employee benefits, and we need the actuarial services for certain aspects. Now, question is, can Mr. A mention in his audit report that he has used the opinion given by Mr. B while arriving at his own audit opinion for financial statements of XYZ Limited? So what is the simple layman question? Can in the audit report name of the expert, I emphasize name of the expert, be mentioned by the auditor? So let us analyze this thing one by one. Whether opinion given by Mr. B actually is the data. Analyze here. Answer is yes, it is the data, because data includes opinion also. Question number second, whether opinion given by Mr. B, I emphasize Mr. B, I'm saying Mr., not saying measures. Mr. B is a personal data.
Yes.
Answer is yes, because this data is given by an individual who is an expert. So now one thing is certain, the actuary opinion is nothing but personal data. Question number third, whether this data, that is the actuary opinion, falls into the definition of processing.
Yes, sir.
Answer is yes, it is processing. Because the words used are recording, organization, structuring, adaptation, retrieval, use, alignment, combination. So very broad definition is there, disclosure by transmission, dissemination, etc. So it is processing also. So it is a data, it is a personal data. Now there is a processing of personal data also. Now fourth question, whether this personal data is falling in the scope of DPDP Act, answer is yes. This opinion must have been received by the auditor in non-electronic form, but it will be converted to the electronic form at a later stage, maybe at the time of filing with the ROC. So it
Yes.
means this act applies to this actuarial opinion. Now the question is whether audit report is a data. Answer is yes, because data includes opinion. Audit report is also the personal data because it is given by an auditor, individual auditor, and you know very well only individuals can be designated to the audit report. And then more important, it is processing also. Having said that, now the question is crystal clear. You tell me, can Mr. A mention in his audit report that he has used the opinion given by Mr. B? Now, what is the context of this question? One thing is certain, DPDP Act is applicable here. Now, second question is whether his name can be disclosed or not. Answer is yes. Answer is yes, but there is a condition. The name of Mr. B can be disclosed in the audit report only after obtaining his written consent. If consent is not there, then this chartered accountant will be deemed violative of DPDP Act. What this consent is, I will discuss in section number 6 and section number 7. So consent part will come at a later stage. So what is the point of learning over here? We auditors need to be very critical when we obtain any expert's opinion. If that expert is an individual and he is giving an opinion which I will be using in my audit report, DPDP Act will be applicable upon me as an auditor. I believe this point is clear to each one of you. Now, question number 2, try to answer this question also. Mr. A is proposed to be appointed as statutory auditor of XYZ Limited in place of Mr. B, the predecessor auditor. Accordingly, Mr. A, prior to accepting the appointment, made a written communication to Mr. B in terms of code of ethics. I believe each one of the listener must be aware that before accepting the appointment as statutory auditor, we have to communicate with the predecessor auditor by virtue of code of ethics. Clause number 8, part 1, first schedule of the Chartered Accountants Act. Now, third point is Mr. B replied that his undisputed audit fees is not yet paid by XYZ Limited, and during the course of his tenure, the management insisted to issue only a clean report. Mr. A hence refused to accept the appointment in XYZ Limited. Now the question is there any duty of Mr. A under DPDP Act? So I give you 30 seconds, each one of you, including the moderator, and please answer my question. I'm not asking you whether DPDP Act is applicable or not. I'm asking a broader question. Is there any duty of Mr. A under DPDP Act? Think on these lines: data, personal data, processing, and then digital personal data. So ask yourself, question number 1, whether any data is coming to Mr. A. Answer is yes, the data belongs to Mr. B. And Mr. B is an individual. So that means it is a personal data. Number 2, whether this personal data is processed by Mr. A. Answer is yes, it is processed. That is why he was able to take a decision that I will not accept the appointment of XYZ Limited. So it is a processing of personal data. Now, whether this personal data is digital also, answer is yes, it could be digital. Maybe by email he must have replied, or maybe by WhatsApp he must have replied, and so on. And if it is not so, maybe at a later stage, it would be converted into digitized form by scanning the things. So if I presume that yes, it will be converted into electronic form, if it is not so, it means it is a digital personal data which is processed by Mr. A. So DPDP Act is applicable. Now, the question arises, if DPDP Act is applicable, is there any duty of Mr. A? Answer is yes. What is the duty? We will see in a while. Now, why these two questions are important? Please understand. In this question and the previous question. In previous question, it was expert Mr. B. In this question number 2, it is the predecessor auditor. Again, the name is same, Mr. B. This Mr. B is called as data principal. or some people call it a data subject also, as a layman data owner. So Mr. B in both the question is data principal, owner of the data. Mr. A, who is processing the data, Mr. A, who is the processor of data, is called as data fiduciary. Why data fiduciary? Because I am the custodian of data. So the person who is the custodian of data is data fiduciary. Now, data fiduciary always need not be data processor, because he can outsource also. So now three terms are coming. One is data principal, second is data fiduciary, and third is data processor. Keep these technical terms in mind. Now, what is the duty of Mr. A? We will see at a later stage, but one thing is certain. The basic duty will be to keep this data confidential in a proper manner. That is the basic limelight duty. Question number third. Mr. A presented his audit report, which was qualified, at the audit committee meeting of XYZ Limited. During the course of such presentation, he explained the reasons of his qualified opinion, for his qualified opinion. The reasons explained were recorded in the minute books of the company. You know very well, whenever a board meeting or a committee meeting happens, minutes are required to be prepared, and the minute book was prepared for this audit committee meeting as well. Now, what happened? In the minute book, in addition to above, that the reasons given by him, some more things were recorded, and these were his name, FRN, that is firm registration number, membership number, office address, number of partners in his firm, and details of his other clients. I emphasize, details of his other clients were also recorded in the minute book of the company. Question is whether DPDP Act applies here. So let us again the same thing. Whether the minute book is containing a data, answer is yes. Data means facts. So meeting facts are there, it is a data. Number second, whether this data is personal data, answer is yes, because this data belongs to an individual, Mr. A, the auditor. Number third, whether this personal data is digitized, answer is yes, it will be digitized at a later stage, because minutes are generally kept in electronic form nowadays. And number four, whether this data is publicly available, answer is no, it is not publicly available. Because it is not publicly available, DPD Act will be applicable. When this data is recorded in minute, whether it is processing, answer is yes. So all the elements are fulfilled. Mr. A here is data principal. The company here is data fiduciary. So DPDP Act is applicable. But now the thing is, now third question which we need to ponder over. Several things may belong to me as data identifiers. I told you, no, that what is data identifier is nowhere defined. So now question is, if you see this fourth point, data identifier number one, his name, then FRN, then membership number, then office address, then number of partners, and then details of other clients. Question arises whether all the data identifiers will be recorded in the minute books. Is it permissible? Answer is no. Answer is no. So we will see in a while as to what information is not required to be kept by the company or the data fiduciaries. Meaning thereby that the other leg of discussion will be what piece of information cannot be processed by the data fiduciary. Question number 4.
Sir, Aman sir, I have a doubt over here.
Yeah.
In this question, you have said that the auditor details are public. They are available for others to see. You said that.
I said these details are not publicly available, like details of his other clients. Because other information will be available publicly.
Right.
But this details of his other clients, it is not made available publicly. Even the website, if you are having a website, as per ICAI website guidelines, names of clients cannot be given on the website. So this information is not publicly available. So question arises, on this DPDP Act will be applicable? Answer is yes. And the other question arises whether details of other clients can be there in the minute book. As of now, answer is deferred. But if I give the answer and spill the beans, answer is no, it cannot be stored. Why? We will see in a while. Question number 4. Mr. A obtained responses. Mr. A is the auditor here. Mr. A obtained responses to external confirmations from various MSME vendors of XYZ Limited. The above responses contained PAN, office address, SIN, GST number, contact information, bankers details. I emphasize the words banker details of such MSME vendors. The MSME vendors comprised of, so whatever responses I received, there were various MSME vendors which comprised of body corporates, total vendors were 10, partnership firms, total vendors were 6, individual proprietors, total vendors were 4. Question is whether DPDP Act applies here, and if yes, to whom it will be applicable. Please tell me whether in this question any data is there which is not, I emphasize, which is not personal data. So Mr. A received several information from MSME vendors. So whatever information Mr. A received from that information, please identify which of the information is not falling into personal data. What is personal data? Data belonging to individual. And if you see here, body corporates supplied data to Mr. A. Partnership firms supplied data to Mr. A. Both are not individuals, and hence information received by Mr. A from body corporates and partnership firm will be outside the clutches of DPDP Act. All the Information Technology Act may be applicable. But information received by Mr. A from individual proprietors will fall into the clutches of DPDP Act. Now come to the second point. What are the identifiers here? PAN, office address, SIN, GST number, contact information, bankers details. All the information except bankers details would be publicly available in general. Bankers details are not publicly available in general. So meaning thereby the question arises, bankers details which are supplied by the individual proprietors are now in the custody of data fiduciary Mr. A. So what he will do for banker detail? Can he retain? Answer primarily is no. It can be yes also, but primarily no. How? We will see when we will discuss the concept of consent, section number 6 and section number 7. I believe up till now, these things must be clear to each one of you. So what is data principal? We discuss as a layman. Let us read the legal language. Who is data principal? Layman was data owner. How they have defined? Data principal is the individual to whom personal data relates. Quite logical because personal data always belongs to individual. So data principal is the individual to whom personal data relates, and where the individual is a child, it includes parents or lawful guardian. And where individual is a person with disability, then the data principal will be lawful guardian acting on their behalf. Who is data fiduciary and data processor? Data processor is any person. So please remember always remember the data principal always will be an individual. Data principal always will be an individual. But data processor or data fiduciary may be any person. Any person includes non-individuals also. So data processor is any person who processes data on behalf of data fiduciary. And data fiduciary means any person who alone or in conjunction with other persons determines the purpose and means of processing personal data. I told you initially that data fiduciary and data processor can be same also. So where data fiduciary is outsourcing data processing, then one more identity will come into the picture, that is data processor. Now, the law says data fiduciary can process. So when I am receiving personal data as data fiduciary, then what I will do? For this purpose, we have two sections which are important, section number 6 and section number 7. And what the law says, data fiduciary can process personal data. Data fiduciary can process personal data of data principal only in accordance with the act and for a lawful purpose. Number 1, for which data principal has given her consent. And number 2, for certain legitimate uses. Before I proceed further, you must have seen a word her, given her consent. It is the first law in India. It is a first law in India where the word he, his, him are not used. Rather, the word she or her, these words are used. Normally, if you see any law, it is written, and if the law is contravened, he will be guilty. In this law, you'll find the words used are she will be guilty. So it is a kind of women empowerment era, and that's why I believe the government of India has used the word she or her in place of he, his or him. But yes, that doesn't mean that penalties will be less. That will be equated to him also, her also. Now, what are two things coming up? If I am giving some data as a personal data to a data fiduciary, then the data fiduciary can process my data only to that much of extent for which I have given my consent. And number second, if I have given my consent or not, it will be immaterial if that data is going to be processed for certain legitimate uses. What I'm trying to convey, either process the data belonging to an individual to the extent he is permitting you, and this kind of permission is not required when data is required to be processed by you for certain legitimate uses. Now, what are these certain legitimate uses? They are listed in section number 7. So let us see one by one. What is section 6 saying? Section 6 provides that consent given by data principal shall be free, specific, informed, unconditional, and unambiguous, with a clear affirmative action, and shall signify an agreement to the processing of her personal data for specified purpose. And this is something important, and be limited to such personal data as is necessary for such a specified purpose. So consent must be given in very explicit manner and for a specified purpose only. And how to give this consent? This consent will be given subject to the notice being given to me by data fiduciary. So data fiduciary will approach me and will seek my consent. And that's why the words used are notice required to be given seeking consent. I have a small question. This law has introduced the concept of consent. And here comes the opportunity for chartered accountants. Section number 4 read with section number 5 and 6. What they say? The date on which this law will be enacted and enforced, you have to obtain transition consent. That means whatever information already is with you, and that information is a personal data in digital form, you have to obtain consent for that personal digital data. That is not a transition consent. It will come in a while also. The law further says the notice which is required to be given to seek consent shall specify details about personal data being collected and the purpose of processing. So whatever consent you will be seeking, you need to specify what is the purpose of obtaining consent from me. And then consent can be withdrawn at any point of time. Now, let us take this case study. X branch of ICAI prepared Google form for organizing a seminar. Various fields to be filled in by the members, including the following. So in the Google form, you were required to fill the following details: your name, designation, job or practice or general, age, annual income, marital status, membership number. X branch stated in the form that above information will be required for processing the registration request for the seminar. Now the question is, what is your view about the data sought by X branch? So can X branch seek all these 7 pieces of information? Before you give any answer, let me go back and see what section 6 says. Especially focus on the emboldened and underlined words and be limited to such personal data as is necessary for a specified purpose. Here, the specified purpose is seminar. And keeping this thing in mind, please tell me, Yati ma'am, please help me with the answers if somebody is giving, which of these 7 pieces of information is irrelevant and is not required to be sought by X branch. And if X branch is seeking this information, it will be contravening the law.
So annual income, marital status, and also
Yes.
the age.
Yes. Age could be relevant because of CP hour requirements, because 70 years of age is the criteria for CP hours also. But yes, annual income and marital status, these 2 fields are irrelevant. And that's why DPDP Act is applicable. And if X branch is mandating that you have to supply this information, number 5 and number 6, it will be contravention of DPDP Act, and huge penalties are there. Penalties we will see in a while. And why this is important to understand, because the law says you have to seek consent, but that consent is only for the necessary purposes. Now, the seminar is a purpose which is specified, but this information, annual income and marital status, have nothing to do with participation in the seminars. Now, here comes the question, Gyati ma'am, for you. from where I began also, I shared the profile and the photograph to the technical support team. And then they shared this information to you. Now, question arises whether this DPDP Act, although as of now there is no problem, but in times to come, whether this DPDP Act will be applicable here on technical support team.
Sir, as far as I can
Answer is
understand it,
yes.
sir, why it would be applicable? Because it is needed for to execute this webinar. This information
But the
is
thing is, they never took the consent from me to share this information onwards. So here processing took place, but processing also includes sharing. And when the sharing took place, they never told me that we'll share this information to some other persons also.
Okay.
Why this is important? On a lighter note, I discussed this example. Why this is important in times to come, chartered accountants have to advise their clients on these very frontiers of DPDP Act. So chartered accountants can play a very pivotal role in drafting DPDP Act policies, SOPs, internal control systems. Now, case study number 2. RSTN company is a CA firm. It is engaged in filing ITR of various companies and individuals. It has with it information like SIN, DIN, GSTN, PAN, DSC, user IDs, passwords, bank account number, etc. On a lighter note, we understand that generally CAs do have the user ID and passwords of their clients also. The question arises whether DPDP Act applies to CA firm, and if yes, what can be the possible extent? I must recall that this topic is specifically for chartered accountants today, although other businesses can also be impacted. So ask yourself, first of all, again, the same scenarios, elements are same. Whether any data is involved over here,
Yes, sir.
whether data fiduciary is a individual or a non-individual. Data
Mm,
fiduciary is non-individual.
non-individual.
Whether it matters, answer is no, because only data principal need to be individual. Now, who are the data principals here? There are two data
First line.
principals, companies and individuals, but companies will not be factored into because the law applies only to data
Individual.
principals who are individuals. So companies are outside. So the details like SIN and so on, to the extent they belong to the companies, they will not be applicable over, they will not be covered over here. Only individuals' data will be covered. So what the answer is, DPDP Act applies to CA firm, and CA firm is the data fiduciary here, data processor also. And then the other question is, if yes, to what extent? What extent means the data which belongs to the individuals will be falling into the clutches of DPDP Act. I believe this point is clear to each one of you. Now, third question, which I asked in the middle of my initial discussion, when Gyati ma'am introduced herself and said that she is from Meerut. Now, please tell me, Gyati ma'am is an individual. Her introduction is the data. This webinar is going on electronically, so it is very much falling into personal digital data. Now, question arises, who is data fiduciary? Technical support staff, and this committee will be data fiduciary because they will be having the recording of this program. Now, question arises, most of us have listened that she is from Meerut. We are data processors or not? Today, if I am say I am Kamal, whether I will be data processor, because one thing is certain, on technical support staff and this committee, DPDP Act is applicable. And because this information is given publicly, so DPDP Act will not be applicable. Matter is on one side. Now, on the other side, I am a listener. Other participants are also listeners. Please tell me whether these listeners will fall into the category of data processors. At least we are not data fiduciary. Whether we are data processors, see over here. Data processor is any person who processes data on behalf of data fiduciary. Are we processing this information? For example, one of the participant told to his colleague or friend that in today's webinar, Kamal was from Delhi and Gyati ma'am was from Meerut. So they are only sharing the information. But are they sharing the information on behalf of this committee? Answer is no. So these are not data processors, and hence this act will not be applicable on them also. Am I clear? Case study number 3. You went for outstation tour and stayed in ABC hotel. Most of the auditors go for outstation audits. The hotel took voter ID from you and scanned this copy of the same, and it was kept by it in its system and duly mapped the same to your room booking details. Whether DPDP Act applies here?
Yes,
Who is data principal? You. That means the auditor who went to stay in the hotel. Who is data fiduciary? The hotel. Is there a data? Yes, data is voter ID. Whether this data is digitized, obviously scanned copy, the law says if it is digitized later stage, it will be covered by DPDP Act. That means the hotel, being a data fiduciary, will be covered by the clutches of DPDP Act. Now imagine a situation, what can be the implication of DPDP Act? Imagine hospitals, imagine schools, banks, insurance companies, educational institutions, CA firms themselves. So many things are going to be impacted. Real estate developers, home buyers data is there. So implication is in large scenario at a wider spectrum. And that's why I was saying that this law has, herald a new era of opportunities for chartered accountants. You can advise your clients with the internal control system, with the SOPs and many other things. And good thing is in this, there is a concept of audit also. Obviously, how the audit will be done, that time only will tell. But yes, audit provisions are also there. Up till now, I will stop for 30-40 seconds. If you have any questions, you can please ask so that I can proceed with further discussions on section number 7. ज्ञाति मैम एक बार देख लीजिए कुछ क्वेश्चंस हैं तो पूछ लीजिए.
So the concept was thoroughly explained by you, so we have no queries as of now.
No, that does mean there can be two possibilities. Either it is clear or it is all clear.
No, sir.
Anyways, so this is now case study number 4. You have published your website. You here means the chartered accountant. And the website collects and processes personal data through cookies. You must have seen when you visit a website, they say accept all cookies, customize cookies. So cookies basically are some small pieces of information so that it can give you personal flavor of access over websites. So question arises, if the website stores cookies, then whether DPDP Act will be applicable upon you? Answer is yes. Answer is yes. So those CA firms who are having websites and they have the scenarios or the systems of taking cookies information, please be careful that DPDP Act will be applicable, and accordingly you have to apply the requirements of section 6, that is consent. Now, let us take few examples about consent. ABC Insurance facilitates sport insurance online. This is done through their website as well as through their web app. Mr. Z applies for a policy, and to complete the KYC requirements, he opts for processing of personal data through a video-based customer identification process. Now it is happening. Like when you go for DSC, online video call happens. So same kind of thing is happening in this insurance company also. Now, prior to, what is the requirement? Prior to collection of this personal data, ABC Insurance Company has to request the data and also specify the purpose of processing the personal data. So this consent is required by virtue of section number 6. Number second example, X, an individual downloads, say, Pharmacy, a telemedicine app. Pharmacy requests for consent of X for processing of her personal data for making available the telemedicine services and accessing her mobile phone contact list. What happened? You must have seen when you download an app, we have a poor habit of allowing everything. Allow, yes, allow, yes, allow, yes. So what happened is Pharmacy app was downloaded and access was being sought to contact list also. And what happened? Miss X gave the consent to have the access to contact list. Now, because of DPDP Act, what will be a change? Let's see the second bullet point. Since phone contact list is not necessary for providing telemedicine services, her consent shall be limited to the processing of her personal data for making available telemedicine services. Are you getting my point? So those apps who are taking access to your phone gallery, contact list, which is not required for processing at all. Now they will be limited and they cannot process that access being given by you deliberately or wrongfully. For consent, there can be some more examples, like food app seeking consent for accessing photo gallery. Now food app is asking you to access photo gallery, need not be required. Radio taxi app seeking consent for contact list may be required, may not be required. Because generally, like Uber app is there, they say share trip. For share trip, when you click on share trip, they will access the contact list so that you can choose a contact number. So to that extent, it could be relevant also. Music app seeking location data, it could be relevant, it could be irrelevant also. So if I am today in Delhi and the location itself will trace Hindi music, I travel to say Chennai, the location itself will give me a flavor of Tamil music. So to that extent, location may be relevant, may not be relevant. Now, when I say may or may not be, it is something where chartered accountants can pop in as advisors. Subjectivity is coming up. Then social media app seeking access to calendar. So all these things like Instagram seeks access to calendar, need not be given because it is irrelevant. Now here comes a question. What if our data fiduciary, as a part of consent, takes an agreement that data principal will not file any complaint to data protection board? Before I proceed, let me tell you what is data protection board. If Gyati ma'am or me or the support staff is aggrieved that our personal data is processed by data fiduciary in a wrongful manner, we have to go somewhere to file a complaint. And for this purpose, a new body is there, which is called as Data Protection Board of India. Now, what happened? The data fiduciary took a consent from us and also took an agreement that me, Gyati ma'am or support staff will not file any complaint to Data Protection Board. Can they do so? Answer is no. So that's the theme of this question. The question theme is, what happens if a data fiduciary as a part of consent also takes an agreement that data principal will not file any complaint to DPB, Data Protection Board? It is invalid if they do so. And it is specifically written also. Section number 6, subsection 2 DPDP provides that any part of the consent referred to in subsection 1, we have already covered subsection 1, which constitutes an infringement of the provisions of this act or rules made thereunder, rules are yet to be notified, or any other law for the timing in force shall be invalid to the extent of such infringement. Meaning there by any provision which debars you to approach DPB is invalid. Now, where consent has been given for processing of her personal data before commencement of this act, what will happen? This is known as transitional consent. And here chartered accountants can come into picture as an opportunity. You can advise your client about drafting of transition consent notice. You can take a note of these words, transition consent notice. And what is the requirement? Data fiduciary should issue notice to the data principal informing her about personal data and the purpose for which the same has been processed, her right to withdraw consent and grievance redressal, and the manner in which she can make a complaint to the board. So you have to draft a transition consent notice by keeping these 3 bullet points in that consent notice. Data fiduciary can continue to process the personal data until consent is withdrawn by data principal. So what you need to understand, each one of the listener, under DPDP Act, once this law will become as enforced law, you have to take the very first step. The first step will be to seek transition consent. Let us take an example. As an individual gave her consent to the processing of her personal data for an online shopping app or website operated by Y, an e-commerce service provider, before the commencement of this act. Let us say Amazon. Now what happened? Upon commencement of the act, what Amazon will do? I mean the Y over here, I am naming Y as Amazon. What Amazon will do? Amazon shall, as soon as practicable, give through email or in-app notification or other effective method information to X the user individual describing the personal data and the purpose of its processing. So we have to take the transition consent. Now, how to seek this consent? What is the manner? Rules will be notified in times to come. So what is the point we covered? Request for consent, but there are 3 quintessential elements of taking consent. Element number 1, the consent shall be obtained in clear plain language. So you cannot use the legal language, legal jargons. You must have seen the law and legal language is a bit different. So you have to write simple plain language. Important thing is, and I would request don't search in Google, option to access such request. So when you will seek this consent now, you have to give the language options. And the options could be the English language or any language specified in 8th schedule to the Constitution. Specified in 8th schedule to the Constitution. And lastly, contact details of data protection officer will be provided. What is DPO? If time will permit, I will cover today. Otherwise, we will skip it. But as a summary, data protection officer is appointed by SDF. SDF means significant data fiduciary. And the job of this DPO is to ensure that whatever data is being collected is not misused. It is something like, debenture trustees who look after the interest of the debenture holders. Somewhat on those similar lines. But no debentures here, data principles over here. I have a question. If you see the words used are any language specified in 8th schedule to the Constitution. So there are many languages like Tamil, Malayalam, and many other languages. Do you know that any foreign language other than English is also there in 8th schedule of Constitution? Jati ma'am, you are smiling, so any answers?
But I was not aware that foreign languages are also the part of its schedule. I, as far as I knew, that only the languages are spoken in India. I was under the impression they are the part
इंडिया
of it.
में तो वो भी लैंग्वेजेस हैं. रशिया, इंडिया में रशिया भी बोलते हैं लोग. लैंग्वेज ही बोलते हैं, फ्रेंच ही बोलते हैं. इंस्टीट्यूट तो कोर्स भी कराता है फ्रेंच लैंग्वेज का. So please take a note, Nepali language. So Nepalese language is also covered in the 8th schedule of the Constitution. You can search in Google now. So what you need to understand, the main important thing as a chartered accountant. So let us assume if you are the advisor of a corporate house who is collecting information, then when they give the option to seek consent, in the option, many languages list will be there. That list will contain English language and all those languages which are given in 8th schedule of the Constitution. And this 8th schedule includes Nepali language as one of the language. Now, withdrawal of consent. She has the right to withdraw her consent anytime. So you can withdraw the consent at any time. And the ease of withdrawing consent must be comparable to ease at which such consent was given. So in Hindi, if I say something, consent लेने में भी नखरे नहीं करने हैं और consent withdraw जब करे कोई सामने वाला तो भी नखरे नहीं करने हैं. So it should be at ease, meaning thereby there should not be any kind of difficulty at the time of withdrawal of the consent. You will not keep the withdrawal of consent highly technical or mechanical or formalized system. Simple thing only. Now, once the consent is withdrawal, whatever consequences will be there, that will be borne by data principle. We'll cover example also. Withdrawal shall not affect legality of processing of personal data based on consent before its withdrawal. Data fiduciary shall, within reasonable time, seize and cause its data processor to cease processing the personal data unless processing without her consent is required or authorized under the Act of rules. It is called as the right to be forgotten. Meaning thereby, let us take an example. Jati ma'am uninstalled Uber app. At the time of uninstallation, she has to give her withdrawal request to Uber app. And once this withdrawal request is given, Uber app has to erase her entire data from the records. If it is not done, she will be agreed party and she can approach to DPB, Digital Protection Board of India. And to represent her case, chartered accountants can go to DPB as authorized representatives. So again, this is an opportunity. Now, let's see these two examples to make the things clear. Example number one. X, an individual, is the user of an online shopping app or website operated by Y, an e-commerce service provider. Y consents to the processing of her, X consents to the processing of her personal data by Y for the purpose of fulfilling her supply order and places an order for supply of goods while making payment for the same. If X withdraws her consent, Y may stop enabling X to use the app or website for placing orders, but please be careful, but may not stop the processing for supply of goods already ordered and paid for by X. So whatever orders were received earlier of withdrawing the consent, you have to fulfill them. Number second example. X, a telecom service provider, enters into a contract with Y, a data processor, for emailing telephone bills to the customers of X. Z, a customer of X, who had earlier given her consent to X for processing of her personal data for emailing of bills downloads the mobile app of X and opts to receive bills only on the app. X shall itself cease and shall cause Y to cease the processing of the personal data of Z for emailing bills. So email data will be erased because you will be using app facility only. It is not that much easy, meaning thereby there are certain other aspects also. Data principal can manage or review consent through a consent manager. What is the consent manager concept? I may not be good in understanding of various nitty-gritties of the law. I may not be good in giving the consent or withdrawing the consent. So a new field is coming up, consent manager. So consent managers are there in the market. You can enter into contract with them, and those consent managers will be assisting you in managing the giving of consent on withdrawing of consent from various data fiduciaries. So, but the condition is that consent manager has to be registered with the board. That means Data Board of Data Protection Board of India. So being chartered accountants, we can also see whether we wish to go to DPB for registration as consent managers. And if any question arises in any proceeding, data fiduciary is obliged to prove that notice was given and consent was obtained as per the act, meaning thereby onus of proof is only data fiduciary only if any contravention happens. Now, what is the caveat here? Certain legitimate uses. Section 7 of the Act provides that data fiduciary may process the personal data for specified purposes. For this, data principal has voluntarily provided her personal data and has not indicated that she has not consented for its use. Let us take an example. X purchases medicines at a pharmacy and voluntarily provides her personal data and requests the pharmacy to acknowledge the receipt of payment through a message to her phone. The pharmacy can process the personal data for sending the receipt. Now, the question arises, what happens in such cases where a cinema theater, for example, insists that the bill would be sent only through an SMS and what's the telephone number? Nowadays, people insist this kind of thing. Currently, this practice is there, but I believe after this law comes into force, there must be a request formally before the number is collected. Now, let us understand what is legitimate use. I will come to this clip in a while. Let us first understand what is legitimate use. So data fiduciary may process personal data for performance by the state or its any instrumentalities of any function under any law for the timing in force or in the interest, sovereignty or integrity of India and or security of India. Meaning thereby, if I say in a bit explainer manner, Section 7 says, data fiduciary may process personal data for these legitimate uses. Now, please take a note of my words. To process the data for these legitimate uses, you need not obtain consent of data principal. I repeat, to process the data for these legitimate uses, data fiduciary need not obtain consent from data principal. Now, what are these legitimate uses? Number one, for fulfilling statutory obligations on a person to disclose information to the state or its instrumentalities. So if I'm a data fiduciary and I'm running a ration shop, so I'm taking your data and I will share this data to Government of India or the state government. And this is my legal obligation so that I can fulfill the ration obligations. In such a case, I need not obtain your consent. Number second, for compliance of any judgment or decree or order issued under any law for the timing in force in India, or a judgment or order relating to claims of a contractual or civil nature under any law outside India. So to enforce the order of a court or a decree of a court, in that very sense, whatever personal data is there, for that personal data, no consent is required. Number third, for responding to medical emergencies involving threat to life or immediate threat to health of data principal or any other individual. Example could be Ayushman app. So when Ayushman app is asking some, permission to access your contact list and other information location, in such a case, no kind of consent is required because it is certain legitimate use. Next is for taking measures to provide medical treatment or health services to any individual during epidemic, outbreak of disease or threat to public health. So almost similar to number third. Now, for taking measures to ensure safety or provide assistance to an individual during a disaster or breakdown of public order. Example is CCTV installed at various places on roads. So when you travel, you must have seen the CCTVs are installed. So like railway stations, airports, roads, traveling, and so on. For that very purpose, no consent is required because it is certain legitimate use. Next is, this is important, and I believe most of the corporate houses will be impacted for the purpose of employment or for safeguarding the interest of employer from loss or liability. So when you engage employees and you're collecting information of those employees are always individual. So personal data is there. And if you're collecting information as an employer for the purpose of employment or for safeguarding the interest of employer from loss or liability, then it will be deemed as certain legitimate use. And in such a case, no consent is required. Please see this case study. RST Private Limited is a company. It has a policy of recruiting new employees after taking following information from them: name, age, address, qualification, marital status, number of attempts to qualify, police record, number of family members, assets ownership, neighbor details, traveling details in last 6 months, bank statements of last 6 months. Question is whether consent is required for each and every above pointer information by RST Private Limited with respect to prospective employee. Any answers? Here, question is whether consent is required or not by the company from the employee with respect to A to L. Can we say that all the piece of information from A to L falls into legitimate use? Or can you see any of the information over here which is not falling in the scope of certain legitimate use? Any information here which is not in context of employment?
And neighbors' details?
Neighbor detail could be one of them. Asset ownership could be one of them. But yes, it is again subjective and much will depend upon facts and circumstances. And that's why chartered accountants will come into play for drafting certain legitimate policy and identifying the identifiers of such legitimate use. And this is the opportunity for chartered accountants. So when we say certain legitimate use, law is okay. But how to have a policy for those legitimate uses, there chartered accountants have a bigger role to play. Now, I have few practical questions here. I read question number 1. In online businesses, often the person or the organization fulfilling the order of data principle is a small business or an individual. For example, an Uber or Ola driver has a platform. Uber or Ola is accessing the data of the person as well as the driver partner. Similarly, for business like Urban Company, now it was earlier Urban Clap, how can the data principles data be safeguarded? So if I say in a simple manner, let us assume I booked Ola cab. My data was shared with Ola as aggregator. The driver was also having my information, maybe the contact information, or if not the contact information, the location. So now I am the data principal. Ola aggregator and Ola driver both will fall into data fiduciary come data processor. Now question arises, Ola aggregator is okay. They will ensure the compliance of this law. Question is whether this intermediary in between me and Ola aggregator, that is this Ola driver, who is also having some piece of information which belongs to me, whether the DPDP Act will be applicable on that Ola driver also. Yes or no?
Yes, sir.
Answer is yes. And that is the sense we need to understand. In such a case, Ola, Uber, and aggregators like these, they have to devise a mechanism for data protection of data principles. And that's why this law has several layers of understanding. Number second, you entered into a commercial complex building which houses your client's office. The security guard took the following details from you that was, say, either written by you on the gate register or fed by you in e-gate monitor register. And what was the information given? Name, address, ID proof, phone number, signatures. So please tell me whether DPDP will be applicable here. Answer is yes, because all these pieces of information are personal data, and yes, this will be captured. Now, I must add one more thing here. Biometric attendance. So biometric attendance is also a personal identifier. DPDP Act will be applicable. And if you try to recollect, I am moving back for a while to show you something so that I can cover it. Just try to recollect this chart. Up till now, whatever we discussed was regular personal data. We never touched upon sensitive personal data. I told you in the very beginning, just see the last paragraph. Note that even after DPDP Act, due consideration needs to be given to SPDI rules. It is the right time now to have a flavor of what is SPDI saying. And that is why I'm covering a summary only. You can download the bare rules from the net. So first of all, let us understand what is sensitive information. So we do have rule number 3 of SPDI rules, very small rules only 5 pages. Now rule 3 of SPDI rule states, SPDI, that is sensitive personal data information. The word sensitive is important over here. So what is sensitive information? As on date, DPDP Act is not defining what is sensitive information. So, but SPDI rule says, and SPDI rules are not the part of DPDP Act. SPDI rules are the part of Information Technology Act. SPDI comprises information relating to items such as passwords, financial information, for example, details related to bank account, debit or credit card, or other payment instrument, medical and health records, biometric data, I emphasize, biometric data, etc. But the rules say it is mandatory for a body corporate. Please underscore the words body corporate. In my experience of last 25 years, I have seen that since 2011, when these rules were enacted, most of the body corporates are not complying with SPDI rules. I don't know the reason, maybe unawareness or maybe a casual approach, but yes, SPDI rules are the law. And the body corporate need to comply with these rules. What the rule says, it is mandatory for body corporates to take reasonable steps to protect the information. Which information? This SPDI information. Further, the body corporate is not allowed publishing any sensitive personal data or information, but there are certain exceptions to this. Exception is basically the legal requirement. It is mandatory for the body corporate to provide privacy policy in which it should be written very clearly that what type of information is collected, the purpose for collection, and this purpose should be clear. Details should be given for disclosure of sensitive personal information third party. Required precaution must be taken by the organization to protect the data. I would recommend to each of the listener, as a chartered accountant, as a corporate professional, please go through these 5 pages of SPDI rules. You can download the rules from the internet. And but you need to remember, these rules are mandatory in nature, which are required to be complied with by the body corporates, because one way or the other way, most of the body corporates will be having sensitive information. The best example is biometric attendance. Your thumb impression is there in biometric attendance. And for that very purpose, this is nothing but a sensitive information. And for that purpose, SPDI rules need to be complied with, and to help corporates, to advise corporates in compliance of SPDI rules, chartered accountants can play a very big role. I skipped 1 or 2 slides. I'm going back to those slides. Just see here. Data fiduciary may process personal data for the state or any of its instrumentalities, like local bodies are there. This could be in connection with providing subsidy, benefit, service, certificate, license, or permit as may prescribed. So you go for a driving license. Now, when you go for a driving license, this RTO will be called as data fiduciary, and it can process the personal data because it is for certain legitimate use, which is nothing but services being provided to you by the state instrumentality. Second point is, she has given her consent previously for processing of her personal data for this purpose, and this personal data is available in digital form or non-digital form and subsequently digitized. Standards we followed as per policy issued by central government or any law for the timing in force. As on date, this rule is yet to come. But yes, we can always say these rules will be quite similar to whatever the provisions we had just discussed. Let us take an example. X, a pregnant woman, enrolls herself on an app or website to avail of government's maternity benefits program while consenting to provide her personal data for the purpose of availing such benefits. Government may process the personal data of X processing to determine her eligibility to receive any other prescribed benefit from the government. This is another example of legitimate use. Moving ahead. So what are the obligations of data fiduciary? Again, a very important element of this law. Up till now, what we discussed was what is processing. Now, some more obligations are there. Obligation number 1, data fiduciary shall be responsible for complying with the provisions of the Act and the rules issued thereunder. He can appoint a data processor only under a valid contract. Number 3 is, if personal data processed is likely to be used to make a decision that affects the data principle, or it is disclosed to another data fiduciary, the data fiduciary shall ensure its completeness, accuracy, and consistency. As on date, we do not have any standards or guidelines, and we are doubtful about the enforceability, but in times to come, rules will be enacted. Data fiduciary to implement appropriate technical and organizational measures to ensure effective implementation of the Act and rules. And important point is breach. So I will request each one of you to be attentive on this personal data breach. Now, before I give details, let us read the line first. Data fiduciary should protect personal data by taking reasonable security safeguards to prevent personal data breach. Now, this personal data breach is quite critical and may be open to many interpretations and litigations in times to come. Obviously, chartered accountants are having the opportunity over here. So what is personal data breach? Let us understand this thing first of all. The law says, what is personal data breach? Personal data breach is any unauthorized processing of personal data or accidental disclosure. Please underscore these words: accidental disclosure, acquisition, sharing, use, alteration, destruction, or loss of access to personal data that compromises the confidentiality, integrity, or availability of personal data. Now, this small paragraph leads to some interpretations. Number one, even accidental disclosure that leads to personal data breach is covered. So you are not relieved even if the accidental disclosure took place. So you have a huge responsibility on implementing systems to prevent accidental disclosure. And when I say accidental disclosure, there are no exceptions where data fiduciary is a victim of a cyber attack or hack. So if the system is hacked, even then it is covered. I must tell you one more thing here. It is the appropriate time. Very recently, SEBI LODR were amended. LODR means listing obligations and disclosure requirements regulations. And SEBI also issued a circular whereby you have to report to stock exchanges cyber incidents. So those reports which you are going to file for cyber incidents need to be harmonized with this personal data breach. It may happen that unintentionally you may commit a blunder. On one hand, you are reporting cyber incidents to stock exchange, and on the other hand, you are not reporting personal data breach under DPDP Act. It will be a contravention. So what the law says, in the event of personal data breach, the data fiduciary shall give the board means data protection board, and each affected data principal intimation of such breach in such form and manner as may be prescribed. So for this, rules will come. Where consent is withdrawn, data fiduciary shall, unless retention is required for compliance with any law, erase personal data and cause the data processor to erase any personal data. I told you earlier also, right to be forgotten. Then, examples could be X registers herself in an online market space operated by Y. Consent was given for processing her personal data and selling her used car. Like we can take example of Car Dekho or let us say OLX. So this could be a scenario. Sale is concluded. Now Y shall no longer retain her personal data. Next, as closes her bank account, bank is obligated under law to maintain records of its clients for 10 years after closing because of PMLA. PMLA requires this retention. So because legally you are required to maintain the records, even if business relationship is no more, you cannot erase the data. So retention is necessary for compliance of law. Bank can retain personal data. One more new concept is there in this DPDP Act, which is called as SDF. SDF stands for Significant Data Fiduciary. Now, who is Significant Data Fiduciary? It is a data fiduciary or a class of data fiduciary which will be notified by government in times to come under section number 10 of the law. So I can say the layman, data fiduciary which is big or large will be called as significant data fiduciary, provided they are notified by the government. But section 10 says that a data fiduciary will be notified by government as significant data fiduciary after considering the following factors. Number one, volume and sensitivity of personal data process. I believe like LIC of India is there. It's my personal opinion as on date. In times to come, things may go otherwise. LIC of India, in times to come, may be notified as significant data fiduciary. Banking companies in times to come may be classified as significant data fiduciary because they have volume of business. Then risk to rights of data principle, potential impact on sovereignty and integrity of India, risk to electoral democracy, security of state, public order. So you see, most of the points are very crucial in nature, and depending upon these crucial elements, data fiduciaries can be identified and notified as significant data fiduciaries. And here comes the other concept, DPO. Other concept of DPO, that is data protection officer. The law says significant data fiduciary shall appoint a data protection officer who shall represent the SDF. And this data protection officer shall be based in India. It shall be an individual responsible to the board or governing body of SDF. And this DPO will also be a point of contact for grievance redressal. This is something which is great, and maybe this is the opportunity for chartered accountants. SDF, that is significant data fiduciary, shall appoint an independent auditor to carry out data audit, and SDF shall undertake periodic data protection impact assessment, periodic audit, and such other measures as may be prescribed. So these measures are yet to be given by the rules. Now, let me come to some other things. I will skip these things because I have covered in a oral sense. I am skipping this right. I am going to section 17, exemptions. In addition to certain legitimate uses, some exemptions are also given to data fiduciary. Section 17 deals with the same. Section 17 subsection provides that obligations of data fiduciary are not applicable where processing of personal data. So you can say these are some additional kind of, you can say legitimate uses or like that. So this DPDP Act will not be applicable on data fiduciary where data fiduciary is processing personal data for enforcing any legal right or claim. For example, when a company goes into CIRP, the insolvency resolution professional is collecting claims and other data. In that very sense, it is a kind of enforcement, and then this DPDP Act will not be applicable. Number second, the processing is by any court or tribunal or any other body entrusted with judicial or quasi-judicial regulatory or supervisory function. Next, processing is in interest of prevention, detection, investigation, or prosecution of offense or contravention of any law. For police department. So police department must be having information through CCTV of various offenders who are violating or flouting the traffic law. In such a case, this exemption is given to them. Processing is of personal data of data principals not within the country pursuant to a contract. Then processing is necessary in context of merger or amalgamation. So various shareholders' data is collected in M&A. In such a case, exemption is there to the acquirer company. Processing is for purpose of ascertaining financial information of assets and liabilities of the defaulter. So, for example, willful default information collected by the banks will be exempted from these clutches. Section 17, subsection 2 is supplementing the scenario. It says that Act shall not apply in respect of processing of personal data by such instrumentality of the state as the central government may notify, yet to notify. But yes, what could be the exemption? This exemption will be given if processing is in the interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, maintenance of public order, preventing incitement to any cognizable offense relating to above, processing by the central government of any personal data that such instrumentality may furnished with. So it may cover embassies. Act shall apply in respect of processing of personal data necessary for research, archiving, or statistical purposes if the personal data is not to be used to take any decision specific to data principle and the processing is as per standards prescribed. So, for example, like All India Institute of Medical Sciences, one of the doctor is into research and development, and that doctor is giving the personal details to All India Institute of Medical Sciences. In such a case, exemption is there, and this clutch of DPDP will not be applicable. Now, Section 17, subsection 3 empowers the central government to notify certain data fiduciaries or class of data fiduciaries, including startups, to whom Section 5, 8, 3, 8, 7, Section 10, and 11 will not apply. Primarily, we have covered all these sections. 17.5 provides that central government, before expiry of 5 years from the date of commencement of the Act by notification, declare that any provision of the Act shall not apply to such data fiduciary or class of data fiduciary for such period as may be specified in notifications. Primarily, what is happening? So if the Act commences today, the government may notify that for next 5 years, this Act will not be applicable to certain class of data fiduciaries. But yes, as on date, this notification is yet to come. So I will skip these two clips because these are not important. Now, penalties and adjudication. Section 33 and 34 primarily deals with the penalties and adjudication, and Section 33 provides that where the board, so board is the adjudicating authority. Board means Digital Protection Board of India. Section 33 provides that where the board, that is DPB, Digital Protection Board of India, determines on the conclusion of an inquiry that the breach of the act or rules made by a person is significant, it may, after providing an opportunity of being heard, impose monetary penalties specified in the schedule. But the schedule I will show you. But before inflicting the penalty, DPB will keep certain factors in mind. Number one, nature, gravity, duration of the breach. Then type and nature of personal data affected by the breach, repetitive nature of the breach, and where the person as a result of breach has realized a gain or avoided any loss, whether the person took any action to mitigate effect and consequence of breach, and timeliness and effectiveness of action, whether penalty is proportionate and effective and likely impact on person if the penalty is imposed. So if I say the layman, penalty may not be levied or penalty may be levied in a lesser amount if there was not a malafide intention. That is what is coming out from this whole scenario. And whatever penalty is imposed and collected by virtue section 34, this penalty will be credited to Consolidated Fund of India. And what are the penalties? Huge penalties are there. You can see here. If there's a breach in observing data fiduciary obligations, then penalty may extend to rupees 250 crores. If there is a breach in observing obligation to give the board or affected data principal notice of personal data breach, so data breach happened and you have not intimated, then penalty may go up to rupees 200 crores. And similarly, some more penalties are there. The lowest penalty is rupees 10,000. If you come to third last row, it is saying breach in observance of duties under section 15. Then it may extend to 10,000 rupees of penalty. But yes, I must tell you one thing very clearly. Chartered accountants can represent for their clients if this kind of penalty adjudication happens. And here the adjudication authority will be Data Protection Board of India. So, Gyati ma'am, from my side, this is the whole picture of DPDP Act in nutshell. If any queries are there, I would be glad to answer those queries.
Yes, sir. We have received many.
Because some time is there, because of no questions, time is saved.
Yes, sir. There is a query from CA Karthik Iyer. He is asking that there have been instances in the past where rift in business, families, or affairs between celebrities have been reported in media without naming them. But the write-up was enough to identify who is being talked about. So, will such instances be covered by DPDPA?
That depends whether the incident which happened with the celebrities was in public domain or not. Now, how it came into public domain will be the test. If that test fails, in such a case, yes, DPDPA will be applicable.
Then another question from CA Rahul. When would the transition consent need to be taken?
As on date, there is no rule specified for the same. So I believe once the rules will be notified, they will be also notifying the timeline within which the transition consent will be obtained. Let us take an example. Say on 31st December, the rules are notified, and one of the rules says that the consent notice must be sent within next 30 days. So automatically will follow the compliance.
Then next question, who is the consent manager under DPDPA?
Who is the
consent manager?
Consent managers are those who are going to be registered themselves with DPB. As on date, such rules are not there. So my opinion is that the consent managers can be the individuals also, non-individuals also. For example, you may incorporate one LLP or a management consultancy company and you can be a consent manager. This is my opinion as on date. Rest rules will tell. So simple things are, consent manager is any person who will be registered with DPB as per the rules specified.
The next question, how the deletion or erasure validation or assurance be obtained?
For that purpose, system audit will be carried out in times to come.
Okay, sir. And then one member is asking, like you have taken the example of mobile apps. So they seek a lot of permission, which are not even required. So how should we treat them? Because
as on date, you cannot treat them. But once the DPDP Act provisions will be enforced, then obviously they will improve themselves. And if they will not improve, then you can approach DPB to file a complaint against them.
Sir. And then next question, what about the status of Data Protection Act in other countries like US and Canada or in any other countries
As
who
on
are
date, UK is progressing very beautifully in data protection laws. Other countries are also following these footsteps, but UK is progressing very beautifully. In UK, we have GDPR.
okay. Um, and then, sir, there's one member who wants to know about this board, DPB board. Means, are they established or are they set up anywhere?
DPB is yet to be established. It is not yet established. So primarily the rules are a bit delayed because of the establishment of DPB.
Okay. Or is it going to be a fast track board or what?
Nothing can be said because different people, different views. But yes, if I give a very nascent example, if you try to recollect 2016, Insolvency Bankruptcy Code was notified, but Insolvency Board was notified earlier than the notification of other rules. The same sequence may be followed for this act also.
And the next question: who would monitor consent manager? Is it any application? Is there any
Application format will be notified in the rules. So rules are yet to come.
Okay, so, then next question from Bhavin Shah. He is asking whether the act applies to mobile selfies or photos taken of friends, celebrities, or any other unknown person.
Yes, in such case, what will happen? Let us take you are my friend, and we went for some trip and we took a selfie with you. So it will be a kind of deemed consent, because had you not given the consent, you would never have been in the photo frame. So when I say consent, the consent will be defined as per normal parlance theories, because it's a kind of personal matter.
Okay, so consent need not to be written. It can be virtual or it can be through gestures
Obviously, yes.
Okay, sir. Members are requested to send their queries because we still have 10 to 15 minutes.
Meanwhile, if there is no query, I must ask you some GK-based questions. I'm stopping screen share. Let me ask you some GK-based questions. And the same request once again, do not search Google. Let us assume DPDP Act is not there. Whether indirectly any such kind of law like DPDP Act is still applicable upon chartered accountants in practice.
Yes, sir. Because
I believe my question is clear. I repeat my question. Let us assume DPDP Act is not there. We all are chartered accountants, and let us assume we all are in practice, or maybe in employmentship, doesn't matter. Whether something on the similar lines of DPDP Act still is there for chartered accountants.
Professional ethics.
Professional ethics. We do have Chartered Accountants Act. And Chartered Accountants Act, Part 1, Clause 1, Second Schedule says that chartered accountants in practice have to maintain confidentiality. Similarly, Second Schedule, Part 2 says chartered accountants who are employees, they also have to maintain confidentiality. Then you come to Code of Ethics 2019 edition. They also say confidentiality. So altogether, we are not isolated versions. We still need to comply with the confidentiality principles, although at a different footing, but still the law is there. What about those chartered accountants in whose offices the digital token is there? So DSC token could be there in your office and the token belongs to the client. And let me assume the client is an individual. Whether DPDP it will be applicable? Answer is yes. Obviously, he must have given you consent. But yes, consent given is different. Applicability of act is different. So act applies and you are not contravening the law. These are two different things. Acha, tell me one more thing. As a matter of interest, I'm asking. This program is going on and say one of the participants took a screenshot of my PPT. Whether DPDP it will be applicable?
So I don't think so it should be applicable.
Because it is publicly available.
Right.
But Understand one more point very critically. Copyright Act would be applicable.
Yes.
So Copyright Act would be applicable, but DPDP Act is not applicable because I made the information publicly available.
And sir,
Huh.
like you have taken an example in the beginning that I have mentioned that I am from Meerut. So again, so I am saying that in public domain. So it should not be covered by DPDP Act.
It will not be covered by DPDP Act because you made it publicly available.
Right. Sir, we have received one query. Is anonymization covered under DPDP Act?
Yes, very much. It is covered. I didn't touch upon this topic today because it is again a big topic to be discussed. Like we have seen the duties of data fiduciaries, data processors today, we have a separate chunk, section number 15, which deals with the duties of data principals also. So Gyati ma'am, if you are going to give any information to data fiduciary which is wrong or which is impersonated, under DPDP Act, you are also guilty. That I have not covered today because the theme of topic was different. And that concept of contravention by data principle is also long. So in the favor of time, I avoided. But yes, it's a very good question. In fact, data principles are also somehow covered by DPDP Act. If they breach, they are also liable. And penalty is not that much in plenty, 10,000 rupees only.
Then CA Lalit Prasad Bhajra is asking, data received by Amazon seller, keep data of sale. Data received by Amazon sellers. They keep data of sales invoice for GST and tax filing. Is data keeping in accounting software will also required as data stored as personal information like address, name, and phone?
Yes. This act will be applicable, but yes, this act will not be applicable to those information. I should say this act will be applicable in totality. But whatever information you're giving, if that information contains unnecessary information, then they will be guilty under DPDP Act.
Okay, sir. And sir, this information would be covered under legitimate use. Just asking.
Legitimate use is exhaustive list. So if you are using a sort like if you are using a cloud-based software, let us take an example, ClearText or any other such kind of entity like say efiling.com, something like this is there, and you're sharing your data with them and they're processing data for GST return filings or ITR filings. DPDP Act is applicable because it is not a certain legitimate use. Nobody authorized them from the government side because legitimate means government is authorizing. Nobody is authorizing them from government side that you can take this data. It is only a contract between me and him. A contract between me and him. I am his client. My personal data is there and then processing. So to that extent, DPDP Act is applicable. Now, when they process my ITR or GST return, for ITR purposes, they can ask my bank details. But I engaged them only for filing GST returns. And they're asking me, please provide your Aadhaar number. I will not give them. And if I give them, in that very sense, this consent will not be taken as a proper consent and they have to erase Aadhaar number from their records. Section number 6 is there. So we have to, isolate as a data fiduciary. I also need to isolate necessary information for specified purposes and unnecessary information for specified purpose. Like if you remember, I took an example of one branch of ICAI organizing a seminar and they're asking information about annual income and marital status. Even if you have given, they are not allowed to store this information. If they store, they have to immediately release it. Otherwise, it will be called as nothing but a kind of data breach.
Then one more question is there. Is pseudomonization covered under DPDP Act?
Yes.
I don't know the meaning of pseudomonization.
Ask this gentleman to reply the meaning also.
And then is data minimization principle recognized under DPDP Act?
Yes, whatever data minimization is called as technically, it is called in DPDP Act is right to be forgotten, right to filter. So when we say necessary information for specified purpose, one part. Second is right to be forgotten. All these aspects are called technically as data minimization. Basically, data minimization words are used by GDPR, that UK law.
Okay.
But we call as data principle, they call it as data subject.
Okay. So these are the only queries we have received till now.
So
We are receiving.
is there somebody from technical support team, or if Mayank is there? Technical support is okay because things are going fine. I just need to ask whether we need to wait for somebody to join from chairman or vice chairperson, or shall we close the session because the topic is over? Please do ask. Meanwhile, let me ask you one more question. I just asked to the technical support staff whether chairperson is joining or vice chairperson is joining, whether this will be covered by DPDP Act. Answer is yes, it is covered by DPDP Act, but there is no contravention because everything is publicly available. Just I saw the poster also, on poster the names were given, so things were available, nothing but in public domain. Now you must be getting bulk SMSs from marketing a team of various companies. Nowadays, you must be getting very spam calls also. DPDP Act is applicable. Answer is yes, because you never gave a consent, no?
Right, sir.
Nowadays, one more practice is going on. If I say as an example, you go to any restaurant. So at the gate of the restaurant, one person is there and he will take your phone number and will give you an OTP and will say you will enter into the restaurant once OTP will come to you because waiting list is there. So now the question arises, DPDP Act is applicable? Answer is yes.
Hello, am I audible?
Yeah, Mayankji. Yeah, Mayankji, you're audible.
Yeah, yes, so the session is about to end around 6 p.m. So we can
I'm saying
conclude
that my topic is deliberated in totality. Only thing is, shall we close the session or chairperson, sir, is joining?
Yes, sir, I will close this now, sir. A chairperson is not available.
Okay.
Okay, sir.
So, sir, let me give you a formal vote of thanks. So, thank you, sir, for such an amazing session on this Let's Explore topic. After attending today's session, it is felt that this session has been very much needed. And we appreciate your ways of explaining the nitty-gritties of DPDP Act in such a short span of time. And you touched upon the types of data, their coverage under the Act by a source of practical examples. And the session has been highly engaging, and you also apprised us about the processing of data comprehensively, data principal, data fiduciary, data possessor, consent, transitional consent, withdrawal, SDF, DPP, legitimate uses, exemptions, penalties, and adjudication. And you also told us the interesting facts about the 8th schedule. DPDP Act is also the first act using the words he and she and her instead of he and us. So it was an amazing session.
Thank you, Gyati ji. Thank you very much.
Thank you, everyone, for joining us.
So thank you, audience. Have a nice evening. Take care. Bye-bye.